started since it's time. I have a little bit of swag to throw out, so I will do that while I'm thinking of it. And the party is going to be on this level, despite what the program says that it will be T level. So people will be gathering for it here. Welcome to our last session of the first day. I think that in many ways the EFF needs no introduction. It's a delight to have them here as always and to talk to all of us about what's going on in the world. So I'll just hand things over.
All right, thank you. Thank you very much. We're always pleased to be here as a wonderful community. We really enjoy being a part of it. So some of you may have been to Ask the EFF before, so you know the deal, but we'll go over it in a bit. But first, let me introduce who's on the panel. My name is Kurt Opsahl. I'm the Deputy Executive Director and General Counsel with the EFF, and I also work a lot with our Coders' Rights Project, where we help defend security researchers who might be facing some difficulties for their research or for trying to present about it. Bill?
Hi there. My name is Bill Buddington. I'm a software engineer at EFF. I've worked on several projects that you might know about. For instance, Let's Encrypt. Also things like Panopticlick, which is a new kind of browser test for trackers and to kind of see how fingerprintable your browser is, and other projects as well.
My name is Eva Galperin. I'm a global policy analyst on EFF's international team. It's my job to worry about the rest of the world that is not the United States. I mostly specialize in work involving extremely vulnerable populations, such as journalists and activists. And I help to write EFF's Surveillance Self-Defense, which is our privacy and security guide.
I'm Andrew Crocker. I'm a staff attorney on the Civil Liberties team. I work on a lot of our national security cases, NSA surveillance, national security letters, and other things. And I work on our Coders' Rights Project as well.
All right, thank you. So for most of this will be your questions, so you get to set the direction of it. We're going to start out with a little introduction, some of the things that we have been working on over the past year. And then we'll get to your questions. So start thinking of your questions now. But I want to lay out a few ground rules. One of the things that we do at the Electronic Frontier Foundation is provide legal advice to people about their situations. Now is not the time to ask those questions. You want to have that in an attorney-client privilege context, and this is, of course, being streamed over the internet, and there's all the people in the room. So if you have questions that are specific to your legal situation or something that should remain confidential, then go talk to us outside of the context of this. But this is more for your broad questions about what EFF is doing and some of the issues of the day. So I wanted to just talk about a couple of things over the last year. CFAA, the Computer Fraud and Abuse Act, has been on our mind, not just this year, but many years. This is the federal anti-hacking statute. It is sort of the primary statute that you may have to worry about if you are engaged in security research which involves accessing computers. And this year there has been some good news, some bad news, and some not as bad as it might have been news. Start off with some of the good news is that the Second Circuit, the federal appeals courts are divided into various circuits. There's about 14 of them, and the Second Circuit has joined with the Fourth and the Ninth in deciding that breaking a terms of service is not enough to make it unauthorized access, not enough to turn accessing something into hacking simply because it was in violation of a terms of service. They had a good quote that I think summarizes a lot of our concerns with the direction the Department of Justice has been going with this. The court noted that while the government might promise not to prosecute checking Facebook at work, we are not at liberty to take the government at its word. And this is the problem. The government wants to answer this with prosecutorial discretion. We'll be cool. Don't worry about it. We'll only go after the bad guys. But the law is the law, and if we want to make sure that they're not doing it, we need to interpret the law correctly and not expand a hacking statute into a generalized way of using criminal enforcement for a violation of a promise. Now, the bad, there continue to be overzealous prosecutions. The Department of Justice has brought them, or in most cases, it's the local United States attorney for that jurisdiction who brings the prosecution using the very broad powers of the CFAA and the harsh penalties. In particular, this year, some of you might have been following the case of Matthew Keys. He was charged with violating the CFAA for defacing a website, something that in the physical world might have been a trespass charge, a vandalism charge, but at a much lower penalty level, maybe 30 or 90 days. But under the CFAA, he's facing up to 25 years. Hopefully he will not get anything close to the high end of that, but that's still a lot to look down. And actually the sentencing is going to be on the 20th, so in a couple of days, and we'll find out what happens there. So the problem does continue. And then the not as bad as it might have been, there were some terrible amendments proposed to the CFAA to make it more hardcore, basically to remove misdemeanors from it, so virtually everything that would be a violation would also be a felony, increasing some of the penalties. We thought this was a step very much in the wrong direction. This was put forward by Senator Sheldon Whitehouse. Which, by the way, sometimes get a little bit confusing to have a senator who's named Whitehouse and then you think about the White House. But this was a senator who brought it forward. When the amendment failed, he blamed it on the secret pro-botnet caucus. I think that, in fact, it was more civil liberties-minded individuals who saw where things were going, talked to their representatives, and put a stop to this terrible amendment. And then what's on tap coming up soon, we have recently argued before the Ninth Circuit Court of Appeal on the question of whether the hacking law encompasses bypassing IP address blocks. So if somebody puts a particular IP address on the block list and then you go access the site by the cafe down the street, is that hacking? Is that the kind of hacking that should be a federal felony? We think it shouldn't be, and argued as much to the court, and we're awaiting their decision. And then moving a little bit outside of the CFAA, but something that I think is of interest to this audience, the DMCA, the Digital Millennium Copyright Act, has some prohibitions against trying to bypass controls DRM that would control access to copyrights. We asked for, and the Library of Congress granted, an exemption for security researchers. It was focused on car hacking, and there was a lot of car hacking in the news that helps set the stage for this, in addition to, of course, finding out that Volkswagen was doing its own internal hacking to shut off the admission system, and I think that helped the argument that independent researchers should be able to should be able to double-check what the car manufacturers are saying they're doing. There were a couple other exemptions going. I think one of them that was also of interest was that you can jailbreak your phone. And you might say, oh, wow, we've been able to jailbreak our phone for years. Well, the funny thing about the DMCA is you have to ask for the exemption every 3 years. And if you don't ask for it again, it goes away. So even if it's fairly obvious that this is the right choice and they've made that choice in the past, you still got to go through the process every 3 years. So we're hoping for some DMCA reforms so that it doesn't get caught in that cycle. But in the meantime, we're going there and we're getting the exemptions. So that's a little bit of the stuff that I work on. I'll turn it over to my colleague, Bill.
Hi, everyone. I wanted to talk about Let's Encrypt a bit. Who here has heard of Let's Encrypt? Show of hands. Great. For those of you who haven't, it's an automated, free, transparent, standards-compliant certificate authority that we launched in kind of conjunction with Mozilla, Automatic, and a number of other partners just last month. So far, we've already had 315,000 certs issued. And if things keep going the way that they're going, we will have doubled the amount of encryption on the web 1 year from now. So this is a great kind of start. I mean, what we really want is for the web to be encrypted by default. We don't want HTTPS to be some kind of outlier that you only issue in banking sites when you log in or have an encrypted session on the web. You want any information that you're transferring over the wire to be encrypted, not only because you want that information to be private, but also because of censorship. In regimes, for instance, where you're not able to access the web as freely as you are perhaps here, they can basically, via HTTP, if you're accessing the web over HTTP, they can selectively block certain routes so that you actually can't access the web freely. You can't actually see all that you want to see. One of the things that we did in Let's Encrypt is we wanted to really make this idea of standards compliance. We wanted to make this an open source and free project. We formed this thing called the Automatic Certificate Management Environment, which is ACME. That's the standard that Let's Encrypt is based on. So it's kind of this dance that is done in order to prove that you have control of the domain resource that you're asking to get a certificate for. So I encourage everyone to kind of look at that standard, see what you can do with it, and also if there's anyone in the room that works for the PKI industry, the certificate industry, to actually build this on your own, build this into your infrastructure, because it's a project that isn't just for us to run, but it's for the world to run, being an open standard. So that being said, we actually are partnered up with IdenTrust, which is already known and trusted by browsers. We have our own Let's Encrypt intermediate cert that's cross-signed in browsers, so that if you install your certificate into your own website, it'll already be trusted by browsers. And not only that, there's this kind of ever-evolving, realm of security when it comes to web security. We have, things like RC4, things like SHA-1 certs that are deprecated. We really want people to be using the latest and greatest in crypto, the best ciphers available. One of the things that Let's Encrypt makes possible is for you to, once you install Let's Encrypt, it actually goes and has this hands-on approach, if you want it to, for your web server. So you manage your certs through Let's Encrypt, and Let's Encrypt actually, whenever you run an apt-get update, ideally, it will basically go and make sure that if the next heartbleed happens, you're going to have the best ciphers available, and you're going to have the latest and greatest there. So that's Let's Encrypt. This last year we were working on analyzing this thing. It's planned by T-Mobile. I don't know if y'all have seen the video of John Ligger, T-Mobile CEO, asking, "Who the fuck is EFF? Who pays you?" You guys do. So basically, T-Mobile last year announced this binge on plan, and binge on is kind of not necessarily a bad idea at the outset. If you look at it, it's this way to basically browse streaming video in a way that's zero rated, in a way that you won't actually hit your data cap with. And for instance, if you are an avid Netflix user, that might be a great kind of benefit for you. You don't really want to hit your data cap just because you're watching Netflix on your T-Mobile device. So this the way that it works is that a website will actually opt into wanting to actually being part of this binge on plan, and that'll mean any data that's transferred from that website will not be accounted towards your data as an end user. The way that this works is that all videos are transcoded down to 480p, and so it's much less data heavy. The problem with this is that once a colleague of mine, Jeremy Galula, actually looked at this and started analyzing how this is all working, he saw that it wasn't just the websites that were opting in, but it was every single website that was getting this, that T-Mobile was analyzing, looking for video streams and transcoding down. Not only that, but it wasn't just videos that were directly streaming off of directly streaming from your device. It was also videos that you downloaded for later use. So it was basically biasing your data. It was biasing based on like a content type. We thought this was a terrible idea. We blog posted about it, and we basically called T-Mobile out on it. Thus, kind of John Laguerre's outrage at this kind of situation. And kind of worked out to our best benefit because the internet came out, show of force, and had this hashtag, we are EFF. We, kind of gave us a lot of pride to see how much support we have out there and how much people are willing to have our back when it comes to, companies doing bullshit things. So those are two kind of more recent developments. The EFF, we launched Privacy Badger last year. If you don't have that installed, you should install it in your browser. It's a browser add-on that kind of is a way to block intrusive trackers and ad trackers in your browser. And it takes this heuristic approach. It looks, at what looks like a tracker. And if it looks like a tracker, then it smells like a tracker, then we can be pretty sure it's a tracker. And so we block based on that. So I don't want to take up too much time, but those are kind of the projects that we've been working on the tech project side of EFF.
Hey there. So I'm going to talk really quick about 3 projects that I'm involved in that directly involve and worry security researchers. You wouldn't think that international team really has a lot to do with security research, but most security research is in fact international. It involves people working together across borders. The security research community is worldwide, and so this is actually something that takes up a lot of my time. We can start with one of the most worrying bills coming down the line. So the UK has spent the last year or two becoming even more of a terrifying surveillance state than it has been in the past. And one of the things that they're doing right now is considering a bill called the Investigatory Powers Bill that is supposed to sort of formalize what law enforcement and surveillance can do in the UK in the interest of gathering intelligence and I quote, investigating serious crimes. Now, the bill is about 300 pages long and designed to destroy your soul if you attempt to read it. But it is vague. It is mostly made of loopholes within loopholes. You could drive a number of trucks through them. And the most worrying stuff is language which makes it possible for the government to conduct mass surveillance in many different ways, so that if different parts of this bill get modified, there are still loopholes you can drive mass surveillance through. And one of those loopholes that we're especially worried about is called bulk interference, where the whole idea is that the government can basically hack an ISP and then look at all the data going through the ISP, as long as there might be intelligence in there or evidence of a serious crime. So as you can see, this really gives British intelligence gathering and law enforcement an unprecedented level of power with almost no oversight and nearly zero accountability. So one of the things that EFF has done about this is we have submitted comments. We have submitted no less than 4 sets of comments to the British Parliament talking about specific parts of the bill and why they worry us. In addition to the sort of bulk collection and computer interference, there is also a section of the bill that specifically seems to target security researchers. There is a section that basically says that if you are working on producing or running some sort of surveillance software, that they essentially reserve the right to hack you to see what you're doing. So security researchers should be extremely worried about this, just in case the security researchers in the room here are not already paranoid enough. Moving on. The other thing that I have spent a lot of time worrying about is state-sponsored malware. So the good news is that we've done a lot to encrypt the web. So there are a lot more websites running SSL. There are more and more people using encrypted communications, including end-to-end encrypted tools like Signal. EFF thinks this is great. But governments have noticed that the increasingly encrypted web is causing them to what the FBI calls go dark. So it's no longer trivially easy for them to spy on all of your traffic. So if they're particularly interested in you, one of the things that they can do is they can compromise your endpoint. And usually the way that they do this is through malware. So I have spent the last several years gathering up state-sponsored malware used by various states against government, not against governments, because when governments spy on other governments, this is mostly not my problem. I care about when governments spy on ordinary individuals, on activists, on journalists, on the kind of people who can't be expected to know to protect themselves and to have this set of skills, where the sort of power differential is exceptionally high, and where the government has the power to, imprison a dissident or send them to a torture center in Syria or just shoot them in the head outside the Kremlin. So these are the sorts of things that I worry about, and the stakes are very high. One of the things that I have been doing is gathering up malware that was used by the Assad regime to spy on opposition figures in Syria. Malware that was used by the Vietnamese government to spy on journalists and people who work for NGOs, including me, by the way, which I thought was particularly hilarious. About a year and a half ago, I was targeted by the Vietnamese government with some malware, and so I turned right around and wrote it up. It really saved me a lot of research time when they send it to me directly. But what was especially worrying was that they also targeted one of my coworkers whose only involvement in Vietnam was writing a single blog post about a democracy activist in Vietnam who had been imprisoned because I hadn't had time to write the post myself. So what we're seeing is that the number of things that you have to do and the sort of extent to which you need to stand up to a government in order to earn its attention is not very high. And so returning to the theme of my work, you should probably be paranoid. And finally, let's talk about what I think is actually the greatest, the biggest threat to security research right now, and that is the Wassenaar arrangement. How many of you are familiar with Wassenaar or export controls? Not bad. We can save ourselves some trouble. Wassenaar. No one, Segoyan hasn't arrived. So a Segoyan appears. All right, so the Wassenaar arrangement is an agreement between 41 countries all over the world, and it mostly governs the export of arms, so things like grenades and landmines and guns. In 2013, in response to the kind of malware research that I do, showing that targeted malware is being used to facilitate human rights abuses, some European lawmakers made some changes to Wassenaar, and Wassenaar expanded to include certain types of surveillance technology. So the good news is that we raised awareness about this very important issue, and the bad news is that the way that the Wassenaar language was written was extremely vague, and basically would, if implemented even as written, would result in a lot of sort of handcuffs on the kind of work that security researchers do every day. Because targeting offensive capabilities is actually really hard, because people who work in security research know that there's really not that much difference between offense and defense. To make things worse, each country has to implement the Wassenaar arrangement changes on their own. So last year, BIS, in the Department of Commerce, wrote up its proposed implementation of the Wassenaar arrangement. And not only did it include the most worrisome interpretation of the Wassenaar language, but it also included an extra little bit, like a cherry on top, in which they proposed to regulate the sale of software involved in the development of zero-day exploits. Nothing could go wrong with this plan. So the BIS and the State Department, the Department of Commerce all issued a call for comments, and the entire security industry got together and said, hell no, this is not going to work out. So right now, BIS is back to the drawing board. They are proposing a new implementation, and while they will not promise that they will go back to Wassenaar this year and negotiate for a rollback of the original Wassenaar language, that is one of the things that is on the table. So one of the things that all of you security researchers can do is to contact your senator or congressman, especially if they sit on important committees, and let them know that this is an issue that you're very worried about, and that they should put pressure on BIS and Commerce and the State Department in order to stop this from moving forward, and also that they should all go to Wassenaar and try to get this language changed or rolled back. Thanks.
Thanks, and we're eager to get to your questions, so I'll try to keep it pretty short. I'll just do the where things stand on two things that I work on, NSA surveillance litigation and EFF's involvement on crypto policy. So rather than going with Kurt's categories of the good, the bad, and things that could have been worse, on NSA stuff I thought I would do things that shouldn't happen only once every 40 years and things that seem like they're going to take 40 years to happen. So on the things that shouldn't only happen every 40 years, reforming NSA surveillance. This year, sort of the biggest thing in that area of our work was the passage of the USA Freedom Act, which was the first major law to reform NSA's activities since the 70s. And this is a bill that EFF spent a lot of time working on. We had our positives and negatives on it, and ultimately we felt like it didn't go far enough, and we withdrew our support for it. But nevertheless, it did a couple of very important things. It ended the NSA's mass telephone records program as it existed and as was sort of called attention to by Snowden in 2013. So as of November of this year, that was no longer happening, and when you made a phone call, it was not necessarily collected by the NSA, which is something that had been happening for a very long time. And that had, consequential effects for our litigation, and I'll talk about that in a second. I just want to note that it did do a couple of other very important things. It introduced some transparency and adversarial process to the FISA court, the so-called secret surveillance court. There's now a pool of so-called amici that can be brought in when they need to hear from another side, when it's just been the government prior to that. And you can be suspicious about that, but some amount of adversarial process and transparency is clearly better than none. And we've seen it work a little bit already. They called in a private lawyer to weigh in on a question about what they should do with the telephone records that they had been collecting for all these years and that they were still holding on to. And he made some important arguments, including noting our cases and the arguments that we have, which is not something that the FISA court had really been super aware of in the past. It took an emergency motion by us prior to get them to at least pay attention to the fact that EFF and other groups were actually suing about this program and that there might be issues with destroying the data that they had collected. So USA Freedom, it did some important things. It also it doesn't go far enough. There's a lot of things that the NSA does that it just doesn't touch. And I can talk about that a little bit too. But by ending the telephone record program, it really had cascading effects on our litigation. So EFF has, depending on how you count, 3 lawsuits about NSA surveillance, and we've been suing about NSA surveillance, mass surveillance, since 2006. So this is the category of things that seem like they're going to take 40 years. We've been suing for a very long time, and it's hard to put a super positive spin on how far we've come in that time. In our sort of flagship case, Juul versus NSA, we've been up to the appeals court twice already. We were just there in December, and we've now gotten kicked back to the district court. And we're not, we've made progress. We're not at the very beginning, but we were really hoping that the appeals court would weigh in on whether the NSA's access to the fiber optic cables and tapping the communications on the internet is a violation of the Fourth Amendment, which is something we feel very strongly. We're right on the law, but we really just can't get the courts to do that because of procedural hurdles like standing, state secrets, that sort of thing. So that it's frustrating. I think there's no way to put a positive spin on that we're still sort of dealing with what Snowden taught us about these programs and trying to get the courts to rule on them. And every procedural hurdle that the government can think of, they throw up. On the telephone records cases, we have 2 cases that are specifically about that. First Unitarian Church of Los Angeles versus NSA and Smith versus Obama. The First Unitarian Church, we have 24 advocacy organizations as plaintiffs, so gun groups, Greenpeace, the National Lawyers Guild, all different sides. And that's really trying to highlight the fact that surveillance, in addition to violating your Fourth Amendment rights, really infringes on your right to associate in private and exercise your First Amendment rights. And that's a theory that we've really been trying to get in front of the courts as well. Now that the telephone records program has ended, we still have claims that survive, and we'd like the courts to weigh in on, whether we're right. But again, the government has thrown up some procedural hurdles, and the court has been extremely slow in considering those claims. We're due to hear from the Foreign Intelligence Surveillance Court exactly what the government thinks should be done with the records they've seized, which go to our standing and go to proving that our clients were surveilled. And so we're hopeful that will move forward. But, again, that's been fully briefed in front of a court for more than a year and a half. So it's frustratingly slow, I have to say. And then just a word on what USA Freedom didn't do. It doesn't touch the NSA's activities under Section 702 of the FISA Amendments Act. So that's what they use to tap into the fiber optic backbone. It's what they run the PRISM program to get things directly from the providers, Google and others. And that's a massive amount of surveillance, and really our Juul versus NSA case should touch that, but as I said, it's been sort of slow moving, and the ACLU has a case on behalf of Wikimedia and other plaintiffs that got kicked out on standing, and so they're sort of in the same boat. You may have seen in the Wall Street Journal that there was some spying on Israel that caught up members of Congress, and all of a sudden members of Congress seem to care about so-called incidental surveillance, where they're not the target of it, but they're swept up in one-end foreign communications, which is what happens under Section 702. And so there's maybe some light there that we can get Congress to pay attention. And the last thing is Executive Order 12333. This is a Reagan-era order that allows spying outside of the United States, and by all reports, there's lots and lots of mass surveillance going on that, in fact, also sweeps up Americans' data as well as lots and lots of foreigners. And this really hasn't been touched by Congress, and is really at this point under the control of the executive. Congress could certainly step in and regulate it, but also President Obama, in line with things that he said when he was running for president and afterward, could rein it in himself by an executive order. He's been doing a lot of executive orders recently, and he could certainly look at this in his waning days in office. So those are the areas that we're going to focus on. And impact litigation is slow, and so we're going to keep at it as long as possible. Hopefully, it won't take 40 years. And then on our involvement in crypto policy, as already mentioned, this sort of going dark rhetoric. This has been a year or two where we've seen a lot of saber rattling by the intelligence community and law enforcement about how encryption is causing their investigations to go dark, and they don't have access to the information they need to track down terrorists or prosecute drug dealers or whatever. The FBI Director James Comey has been really on the forefront of this and saying some stuff that this audience obviously knows is inaccurate. This idea that there could be a backdoor to communications or a golden key or whatever you want to call it. Fortunately, the response from people like you and from the tech companies and from just ordinary people has been we don't think that's a good idea. It's not worth the risks. One of the ways that EFF has really tried to harness that support is with another group called Access Now. We organized SaveCrypto.org, which was a petition to the White House through the We the People site, and we got more than 100,000 signatures, which is what you need to get the White House to respond. Their response was a little mystifying. It was sort of a non-response response, but it did lead to us meeting with them and sort of telling them what we thought their position on encryption should be. Right now, their position is we don't support any legislation that would backdoor encryption for now. And when we have a year left in office for this administration, that's not quite good enough. So some of our demands are, this is a statement that should come from the president. He should say, I don't support legislation that would weaken encryption in any way. He should clarify what he means when he says, I think he said, I'm a strong believer in strong encryption, which is, to this audience, doesn't mean a whole lot. And so he should clarify that means he supports end-to-end encryption. He supports encryption of smartphones and other devices that's only decryptable by the user. And then he should say that he doesn't support any executive action by any member of the executive branch that's inconsistent with that. So one thing that we're very worried about is that people like you who, run services that use encryption are going to get friendly calls from the government that say, it's your patriotic duty to introduce some sort of backdoor into this. Why don't you do it? People are going to die. And so we really hope that the government won't do that while sort of publicly saying that they support strong encryption. So that's where we're hoping to see from the White House. Meanwhile, some members of Congress are threatening to do this, and we wouldn't be surprised if encryption legislation was introduced in this coming session. Senator Feinstein has said that she'll do something. Burr as well, and we will be watching that very, very carefully, and we will muster all that we can to oppose it if it does come to that. And you might have seen that a New York State senator introduced a bill that would require all smartphones sold in New York to be decryptable. That's a terrible idea, and I think as an initial matter, states can't even regulate in that area. It's unconstitutional. I would be surprised if that went anywhere, but it's gotten some press recently. With that, I think we can open it up for questions, right?
All right, thank you. So we have a microphone here in the center, so if you just go line up behind that mic, and then you'll take your questions one at a time. We got about a little over 20 minutes before 5 o'clock, so hopefully I have time to hit your questions. Yeah.
Hey, thanks for taking questions. I really appreciate it. So the EFF gets a lot of praise, unless maybe it's from CEOs of major telecoms. I was wondering if personally, each one of you, what you thought maybe in the past year EFF has done wrong, or the EFF could have done better.
All right, so the classic interview tough question. What are your greatest faults? You can try with we're too much of a perfectionist. I think some of the things that we would have wanted to see, we tried to stop CISA from passing. This is the information sharing bill. That it wasn't a particularly good bill. It enabled more surveillance. By giving a immunity to telecom companies to give out information for the customer, it took a check away from them to try to not make mistakes if they're immune from those mistakes. And so we attempted to do that, and we've actually successfully in the past pushed back against some other forms of information sharing bills. But then this time it didn't go through as part of the omnibus bill, and we weren't able to rally the support to stop it. Anything else, or was just
this?
All right.
I was actually going to ask about the version of CISA that passed in omnibus. Can you expand on it a little? How does it affect us? What do we need to worry about? Is there anything that we can do to defend ourselves?
So good question. So this is the information sharing bill. It actually, I think it passed as like the Cybersecurity Act of 2015, but we know it as CISA under its original name. And I think the greatest challenge of it was I was just sort of alluding to is it provides for ways in which companies can share what's called cyber threat indicators, but these are sort of broadly defined, some vague definitions that would allow it to go beyond, and it has some liability limitations so that the companies who might be sharing this information can get it wrong. And there really wasn't a serious threat if a bad actor who is engaged in malicious behavior and you share their information, they weren't really going to show up in a court and sue you for this because they're busy trying to hide their tracks and they're living, overseas and behind 7 proxies. The concern that perhaps they were worried about is what if they put an innocent person's information out there, because an innocent person might be offended if their information was shared with the government and there were some consequences to that. And so the liability limitations sort of make it so the companies don't have to worry so much if they get it wrong and start putting out information. And that takes away a check on some spying. And I think the other big challenge, at least I have with this bill, is they spent this tremendous energy, coming up with this bill, writing it, debating it, and so on. And it really isn't getting to a lot of the core problems that are affecting our security. It's not going to do anything to make people update their software more frequently and make sure they have the latest patches. It's not going to do anything to convince vendors to be very responsive to vulnerability reports and get patches out as quickly as possible. It's not going to do anything about the trouble with things that have firmware that has gone bad and there's no easy way to get an update to them. There's a lot of serious problems we have with our computer and network security, and sharing around the signature of a malware file it's useful, but that was already being done. There already were threat indicator databases. People would submit things to that. Like a lot of the things that are part of this bill were happening. And the most valuable thing for information sharing is the government could start being a little less over-classifying and realize the value of actually sharing some of the information it receives with targets, with people who have vulnerable systems and such. And they don't need a bill to do that. They can just start doing it under an executive order. So I guess that's one of the greater tragedies of CISA, is they're putting so much time and effort into something that isn't going to be very useful and has the potential for enabling more surveillance.
Hi. So the EFF seems to be mostly focused on the legislative and judicial branches and organizing, your power and getting what you want done through those branches. And I feel like those branches are mostly influenced by the executive branch and their decisions because of how much they want to keep confidential, keep soldiers safe and whatnot. And on top of that, people high-ranking in those areas, like the FBI director, are not particularly educated on technology, not very good at it. So my question is, do you have representatives or education of the DoD?
Please.
I'd actually like to push back on some of this. I don't think that Director Comey is an idiot. I don't think he doesn't know how the internet works. And I think it's really hard to get anything done in Washington, D.C. if you assume that the problem is that your enemies are stupid. Our problem is not that our enemies are stupid. Our problem is that our enemies are very smart, and they know how to get their way. And this is how you get this sort of going dark rhetoric. I think Comey understands that the FBI is not, in fact, going dark, and in fact, that the NSA's collect everything, just throw everything in the haystack method was not useful. In fact, former NSA directors have come out and said that this particular way of going about things doesn't work. So I'm not really sure that education is what they need. There are people in government who don't understand how the internet works. And frequently those are governors and senators and congressmen, especially heads of committees, which I find very worrying, and judges. And to that end, we actually do a lot of education We have been brought in to brief people in government fairly often, but I don't think that specifically the DOJ or the DOD or the FBI is lacking in that kind of expertise. They're just using rhetoric that makes you think that maybe they don't know how the internet works because it's going to get them what they want.
The other thing that's really nefarious about the going dark kind of rhetoric is that it's actually also just completely not true in terms of their ability to spy on specific targets. They can certainly deploy things, as we know they've done through targeted 0 days, and that's kind of something that we've seen through released documents, through FOIA and their equities program, that they actually haven't really shared these 0 days and haven't actually helped the security overall of companies that these 0 days target. So that's another thing to keep in mind.
And just that said, I also just want to say that nevertheless, we also have been involved in talking to people in government and trying to provide technical assistance, and we've had some good conversations with some people. There are actually some very smart people at the White House's Office of Science and Technology Policy who at least know what they're talking about. The government is a very big thing. There are certainly other people who might know less, and so it is a multi-front approach.
Thanks for your responses. Didn't mean to imply they're idiots. That's not what I was going for.
I had partly the same question as her, but to kind of build on that, what can we or other security professionals, people who are interested in security and privacy, do to maybe get involved in the process of writing bills that are actually effective for what they want and what we want?
So we have a number of campaigns on act.eff.org, and some of these campaigns actually target Congress. And I think that one thing that's extremely valuable is for Congress to know when you actually compose your piece of mail to Congress, to let them know that you're actually a software developer, you know how this technology works, you know what's at stake and how this all actually is put together, and having that extra emphasis on the fact that you're a technical person, you're someone that knows in this field intimately, is extremely valuable for members of Congress to know. To have, we do a lot of mailings that target Congress, and a lot of them are, we have the default text, but we also encourage people to add that, their specific context, their specific notes to our campaigns, because they that actually is valued more than say just the default text, for instance. Other things that you can help out with, if you go to our GitHub, you can go to github.com/EFF.org, and that'll show you a bunch of projects. And in addition to contributing to the software, also just opening issues, letting us know about when our software fails, because our software isn't 100%. It has failure cases, and we don't necessarily know about them. And then people come up to the table at conferences like this, and it's like, do you know that there's this bug in your software? It's, Privacy Badger is doing this thing. We're like, oh, great. Well, thanks for telling us now, but you can actually open this issue and help us out in a trackable way. So that's definitely something that we really value. Getting that feedback from users is really valuable to us as well.
I also have a couple of things that the people in the security industry can do. One of them is for the people who work in threat intel and the people who work with users who are in extremely vulnerable populations, when you're making your products, think about those vulnerable people. Think about a user in Syria or a journalist in Turkey, and when you're coming up with your threat model, you should include them, and you should definitely think about how you're going to keep those people safe, because there's really a lot at stake for them when they use your products. One of the things that I hear most often from security professionals when I come and I ask them about, journalists in some obscure authoritarian state is, oh yeah, we've seen plenty of malware come from X state. Just nobody cares because it's not particularly sophisticated and there are not a lot of users. So start thinking about those people, and when you see that kind of malware coming down the pipe, give me a call. You can email me at eva@eff.org. I'm very interested in this stuff, even if traditionally the security industry is not. The other thing I wanted to talk about real quick are comments. As I mentioned before, EFF has filed comments in response to an open call for comments from civil society and academia and the security industry on the investigatory powers bill. We also filed comments in response to a request for comment from BIS about their proposed implementation of Wassenaar. When we did, there were also dozens and dozens of comments from individual security researchers, academics, and also independent security companies talking about how this legislation was going to affect them and their business. And this stuff really makes a very big difference, and this is stuff that every one of you can write.
One thing I forgot to mention is that you're also here in D.C. I mean, you have a right to the ear of your member of Congress. And they have staffers, and you can call them and actually make a meeting, organize a meeting with them, and you'll have their ear. It's important to realize that they're here to serve you.
And don't forget about the state and local level. This is particularly on the surveillance side of things. These are technologies that we see filter down to state and local law enforcement. Stingrays being one that we've seen where the funding comes from the federal level, and then the state and local law enforcement buy them, and you're using them often, in a very secret way where the community doesn't even know they're being used. And we've seen some really great work being done by activists locally, getting access to contracts and other purchasing orders, and just finding out what technology their state and local law enforcement are using. We're based in California. We've tracked California legislation and other stuff for a long time, and we're increasingly doing that outside of California. But local ACLU affiliates are doing that as well, and there's nothing stopping you from filing Public Records Act requests to get access to that kind of information. And being somebody who can interpret exactly what a certain Stingray model is capable of is actually very useful.
Go ahead.
The status quo when personal information is stolen these days is to give a year or two of identity theft protection and call the problem solved. And it seems likely that folks are going to realize that this has a specific cost, and they're going to start weighing that cost against upgrading IT systems. And I was wondering, if you sort of think it out, if an upgrade is $100 million and providing identity theft for N number of users is $10 million, are going to, put off upgrading IT systems and just weigh that risk against the cost. And I was wondering if this is something that's on your radar, if it's something you're concerned with, if you think it's legitimate, and if there's any recourse for, if you think there's, legitimate negligence going on in terms of protecting yourself.
Primarily where we have worked in that area is looking at data breach notification issues. That at least getting info, people are informed that there's been a data breach that affects their data, so they can take actions to protect themselves. It's not clear to me that a year's worth of identity theft protection is that strong of a protection. If somebody has your info and they're a determined adversary, it may be somewhat useful in some circumstances. So the first thing we've been focusing on is notification. And what we have right now is it's a mix of state laws, various state laws that have different standards. There have been attempts to have a nationwide data breach notification at a federal level. And there might be some advantages to that, so long as it was a good standard. The advantage is that it's a lot easier for everyone to be on the same standard. That therefore all the companies know what to do when they have a data breach. They don't try and play interesting games about where the data is located, depending on the laws and things like that. The danger, of course, is that anything that goes through the legislative process has a possibility of being watered down and having something that becomes ultimately not what you had hoped for in the end. The alternate thing that has been happening, we haven't gotten very directly involved in, but I think what you're talking about, it's private lawsuits that are going against people who have had data breach to use the class action system. And that can sometimes be good. It's a good way to put a incentive for people to be good. But also on times a class action lawsuit doesn't end up doing very much to help the class and does a lot to help the attorneys who brought the lawsuit. And so that might not be the most efficient use of resources all the time, there are good plaintiffs' class action attorneys who really are trying to help the class, and there are some who are not. And it'll depend on how the particular case goes.
Thanks.
I want to follow up on that more from the corporate standpoint than from the user side. A few years ago at RSA, I heard a panel talking about whether escrowing money to remediate the civil and possible criminal penalties after a breach was a legitimate alternative as a cybersecurity mechanism. And this is the first year that in my day job I've actually heard a company talking about that when talking about the budget for security. Are you seeing any of that, and do you think it's a defensible legal strategy?
Okay, so I have not actually seen this. To make sure that we understand it correctly, this is the notion of rather than put the money on security to prevent a breach, we'll put some money aside to pay for one when it happens.
Yes.
And so I hadn't heard of that in this context. Insurance. It's essentially insurance, and I have heard of some things that were similar in other contexts that turned out to be somewhat badly, like when car manufacturers found out that there were problems with their cars, like they could flip over and explode, and they determined it was cheaper to put some money aside to pay the lawsuits when they flipped over and flowed than make them so they didn't flip over. This worked out badly when they got caught. And as it turned out, that was turned out to be a very bad fact against them in the lawsuits over those things. Now, car flipping over, exploding, killing the occupants has hopefully, we're not talking about the kinds of security breaches that would lead to that activity where someone was physically harmed. But I think it is better for society if we invest in having good security. And, it's hard. You may ultimately still have a breach despite the best efforts, but do the best efforts. Try and make sure that you're in the top of the game. And so someone has to try really hard. Maybe they have to burn an O-Day. They have to do something extra special to get out the information, and it's worth the investment.
And that came up in the panel at RSA, and the counter-argument is corporations are not answerable to society, they're answerable to their shareholders, and if it's less expensive to do this insurance or escrow, that may be in the benefit of the corporation. Thank you.
All right. Well, thanks everybody for your questions. We've come to the end of our time, and we have to get out of here pretty quickly because they're setting up for the party tonight. Thank you so much. We really appreciate your support. I want to let you know that if you donate to EFF down at our booth this weekend, there's a challenge grant that is doubling the donation, so we'd love to meet that challenge, so come on down there. And then we'll go outside, talk if people have further questions, and then later we're going to be headed down to a bar called Maddie's just down the street around 7 o'clock for further hanging out and enjoying. All right.
Thank you.
Thank you.